Lordship.
Yes.
I beg to mention one bail application to be taken up today as unlisted.
Today? Why today?
Lordship, only CD has to be, LCR has to be called for. Lordship. There is a urgency in this matter. We'll try out, Lordship. If I have already filed this morning, Lordship.
Okay. Yes.
In Lordship.
19.
Lordship. Kali, this matter may be taken up on Thursday, Lordship. That's 11, Lordship.
Thursday?
Yes, Lordship. I have taken consent from the other party.
You are Mr.
S. Tapin.
S. Tapin.
Lordship. I am for the petitioner.
Mr. S. Tapin, the learned counsel appearing for the petitioner, submits that matter may be taken up on next Thursday.
No, this Thursday, Lordship.
Sorry?
This Thursday.
This Thursday.
Lordship.
Thursday, that is on Thursday will be
11. Lordship.
11th. Prayer was not opposed by, prayer is not opposed by the learned counsel appearing for the respondents. Let the matter be listed on 11th.
All right.
My lord, I beg to mention item number 13.
13?
Yes.
Yes.
The affidavit in opposition filed today and matter may fix after 1 week and copy of all the sub.
You are Mr. Tartarum?
Yes, I am for Tat.
Mr. Tartarum, the learned counsel appearing for the respondent submits that he has filed an affidavit in the instant matter today only. Therefore, he is seeking adjournment of the matter so that the affidavit can be brought on record. Let the matter be listed on
After
let the matter be listed after 2 weeks.
matter may fix for admission hearing.
The matter let the matter 2 weeks there will be holidays. So after the holiday, let the matter be listed after the ensuing holidays.
For hearing.
For admission.
Yes, admission.
Lordship, in this matter, I am for the petitioner. There is an interim that may continue. Lordship.
Let the interim order so passed earlier shall continue till the next date of listing.
Obliged.
Lordship, I beg to mention 2 unlisted bail application.
When?
Today.
Today it will be difficult. Today there is not much time.
Lordship, this urgency.
What is the urgency?
Accused person is in the custody almost 82 days.
Huh?
And the accused person's father is an ailing patient. So he is almost in the custody for 82 days.
82 days. 90 mandatory period 90 days.
Yes, Lordship. There is no family members to look after father. Father is an ailing patient. So it's just very urgency, Lordship. So it will be taken up today, Lordship.
Okay. Let call for this.
Much
Here, amongst the unlisted matter to criminal petition, it's a crossing of FIR and charge sheet.
It will be tomorrow. Tomorrow or day after tomorrow.
Yes, or day after tomorrow.
Day after tomorrow. Yes.
My Lordship, I beg to mention item number 18 on behalf of S.R. Rabha.
18.
Yes,
You are appearing for
S.R. Rabha.
S.R. Rabha,
Yes.
petitioner.
Yes, Your Lordship.
MS so-and-so, the learned counsel, appearing for Mr. S.R. Rabha, the learned leading counsel in the instant matter. Let the matter be listed on.
Tomorrow, because he's coming tomorrow.
It's coming tomorrow.
Yes.
Okay, let the matter be listed tomorrow.
Much.
Tomorrow, that is 9th.
My lord, I beg to mention item for listing on 10th. It's a criminal petition.
What is the urgency in that?
My lord, there's a DPC sitting currently, my lord. There's a DPC sitting currently, and the petition as a result of pendency of this case has been delayed. His promotion has been delayed, my lord.
DP sitting when?
The DPC, my lord.
DP sitting when?
Oh, my lord, it has already begun, my lord. The process already begun. That's why there's an urgency to dispose of
Day
this
after
matter.
tomorrow.
Yes, my lord. Day after.
Okay.
Much obliged.
My Lordship, I beg to mention item number 20, Lordship. Item number 20, Lordship.
20? Yes.
Lordship, here I'm for the petitioner.
Yes.
Lordship, kindly matter may fix after vacation, after puja.
You are Mr.
Tita, appearing on behalf of Tita Gum, Tavatagum po.
Okay, well, Mr. So-and-so, learned counsel appearing for T. Tagum submits that you have intimated the respondents, right?
Yes, Lordship, yes.
With the consent of the counsel for the respondent, let the matter be listed after the ensuing vacation.
Obliged, Lordship.
Item number 1.
Admission kini pasal apa? Kini luar besar. Bail hearing kini. Bail hearing officer orders kini. Yes. Yes.
May I please, my lord? This is a criminal division petition against the order of the trial court going CGN and upheld the said judgment by the Honorable Court of District and Session Judge Teju, my lord. Now, here in this case, I am not taking the much more time of this Honorable Court.
So we'll admit this.
Yes, my
We'll admit this.
Issue notice.
Oh, yeah, we will admit this issue notice.
But there is an urgency, my lord, because you are not.
Vasu
this,
Rai.
this petitioner were convicted for the offense 323 for 6 months imprisonment and 1,000 fine. Now,
तू यहीं पढ़ ले
here
बेटे
in this case, the
इधर आ बार बार ये निकालने से फिर ये कैसे हो गया वायर निकाले ना
मैं तो वैसे इसका
देख ऐसे करता हूँ तो ये आ जाता है ऐसे करता हूँ फिर ये
now here in this case, my lord,
No, we'll issue notice and we will grant you bail.
honor, my prayer is for bail also.
That's what I'm saying. I mean, it will be suspended, 6 months of imprisonment,
Yes,
isn't
yes,
it?
my lord.
Yes. Heard, Mr.
MK Singh.
MK Singh, the learned counsel appearing for the petitioner. Also heard Mr. GAT, the learned counsel, learned APP for the state, APP post for the state. This is an application under section 438/442 of BNSS, read with section 397/401 of CRPC, assailing the impugned judgment and order dated 4/11/2025 passed in criminal appeal number 02 in bracket LDV/2023 by the learned district and session judge Teju, Arunachal Pradesh, wherein Arunachal Pradesh, wherein the accused, wherein the petitioner has been convicted, where the petitioners, how many are there?
2 petitioners, my lord.
Wherein the petitioners were convicted under section 279/341/353/323/34 IPC.
Convicted for 323 only, man.
Hmm?
Convicted for
Convicted
323.
That's what I was looking.
Yes, man.
Page number 93, my lord.
Convicted under 323 IPC. Yeah. Others you cut 323 IPC. Issue notice on respondents. Issue notice on respondents by way of speed post, returnable within 4 weeks. Notice to respondent number 1 is dispensed with since Mr. G. APP has put in his appearance in the matter. We have not filed separate petition or same
File, separate
Huh?
file, man.
File, my lord.
I is there.
Yes, man.
You write. Same you write hardly so and so, the applicant. This application has been filed under 430 of BNSS, read with section 438 of BNSS 2023, praying for suspension of sentence passed by learned district and session judge Teju, Arunachal Pradesh, while its judgment in order dated 4/11/2025 in criminal appeal number 02 in bracket LDV/2023.
Concurrent finding.
2023, praying for allowing the accused convict to remain on previous bail or face bail till the disposal of the instant petition, full stop. After hearing the learned counsel appearing for the respective parties and having found materials for admitting the connected criminal revision petition. The scope is of the considered view of the accused applicant. You are still on bail or what?
No, no. NBW has been issued, Your Honor, because in the judgment, Your Honor, of the Teju court, directed me to surrender before the jail authority.
When?
That was not the procedure. It was page number, my lord, page number 34 of IA.
30?
34 of the IA.
So NBW issued.
Yes, my lord.
So you have challenged this order also?
Yes, my lord.
Order dated with
14/11/2025.
Huh?
14/11/2025.
14/11.
Yes, my lord. 14/11/2025. Signature is apparent. Signature and seal.
Judgment, no, no, this is an order, my lord.
This is an order connected with the main judgment, my lord. Yes.
NBW has to be challenged, my lord. Again, along with-
So what is doing? No, that previous line. No, don't write after the hearing. You write further. You write. The learned counsel appearing for the petitioner submits that by order dated 14/11.
Yes, my lord.
Date is not coming here.
That is apparent at the seal of the CGM.
14/11/2025. The learned Chief Judicial Magistrate Rohing, Lower Dibang Valley District, AP has issued NBWA against the convicted persons. So you have not surrendered on the date.
No, what?
Which was the date of surrender?
My lord, as per the order of the Honorable Session Judge Teju, it was written in the.
You have been asked to surrender when?
My lord, on page number 123, my lord. Page number 123 of main criminal petition, criminal evidence petition. Page number 123. Page number 123. Both the appellant Avinash Sumra and Ilaman shall be taken into custody of District Jail Teju to receive the District Jail Teju, Your Honor. This is not a procedure, Your Honor. The court may direct me to appear before the CGM Rohing, where the original trial judgment has been passed, and thereafter that court will send me in the judicial custody.
Submitted, issued NBWA since the accused applicants in terms of the order dated 4/11, right?
Yes, my lord.
In terms of the judgment and order dated 4/11/2025 have not surrendered before the deputy before the DYSP, District Jail Teju. in view of the admission of the connected criminal review petition, this court observes the considered opinion that the order dated, the judgment and order dated 4/11/2025 as well as 14/11/2025 are hereby suspended. Hereby suspended, full stop. The NBWA issued white order dated 14/11/2025 is kept in abeyance. Kept in abeyance. It is also directed that the accused applicant shall be released. Now where are you now? You are
I am-
surrendered. No,
Uh,
surrendered or not? No.
you haven't
No.
surrendered as yet. No, you're outside only
Yes,
without any bail and nothing. Huh?
without any bail, my lord.
Kept in abeyance. Then you write that it is also directed that the accused applicant that the petitioners shall be released on furnishing of a bail bond of rupees 5,000 each.
Obliged.
5,000 with surety of like nature to the satisfaction of CGM.
Rowing CGM. CGM rowing.
To the satisfaction of rowing CGM. Rowing CGM. No other conditions are required. Correct?
Not required.
6 months only.
Yes, madam. Yes.
I mean, that kept in abeyance you have written, and then you keep it like till the disposal of the revision.
Obliged.
And I am maybe disposed of them.
The IA, in view of the order passed, in view of the directions passed, the IA is disposed of as allowed.
Your lordship, record. of the-
TCR in the instant matter, the main appeal you write, TCR in the instant matter. The registry to call for the TCR in connection with
GR case. GR case number 70 of 21. Arrange-
No, I mean, the session,
GR case number 70 of 2021.
from which court? From the sessions court?
No, my lord.
It will be there in CGM's court.
CGM code.
Perhaps your lordship, the appellate court has written the
Appellate,
record.
maybe it has been returned.
Yes, ma'am.
Return.
So call for the TCR in connection with GR case number 70/2021 from the court of CGM.
Rowing.
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 Obliged.
Obliged.
Item number 2.
None appeared for the petitioner when the matter was called for. Though learned APP appearing to the state is present. For interest of justice, let the matter be fixed after a week.
Item number 3. May I, Lordship? Lordship, this is a petition under section 528 for quashing of an FIR of Alo PS case number 42 of 25, which has been registered under section 318, subclause 3 and 4, and section 319, subclause 2, with section 338 and 340 of BNS. Coming straight away to the FIR, Lordship. The FIR is, Lordship, on page 30, Annexure 9.
Please.
30.
So you have taken some, extra money.
Lordship, that also, the extra money also, since Lordship, I was employed as a casual,
Pays.
but an FIR,
Pays.
it's 30, Lordship. In nutshell, before going to this FIR, I'll just say, Lordship, since I was an casual employee, I was regularized by conducting a trade test by the department. So since Lordship, I was on a trade test, I being selected by the department after serving for more than 14 years. the trade was conducted only for a employee who had completed 10 years. Since I had completed 10 years, also I'd appear for the trade test. And Lordship, after being regularized, I was transferred from the division of RWD Pasigat to ALO, Lordship. So during that transfer, since I've been regularized, Lordship, during that, Lordship, my 3 months of wages as a contingency was given in my account, Lordship. And in respect of that also, Lordship, the department has stated that there was a clerical mistake inadvertently done by the department, not by me, Lordship. So this is, Lordship, and this FIR has been lodged by my estranged husband. Since, Lordship, I had filed in domestic violence as well as a title suit of divorce against him. So before this, Lordship, this is the FIR. May I read, Lordship? The page 30. To the officer in charge, Police Station Alo, District West Siang Alo, dated Alo, so in 14 July 2025. FIR against so-and-so, that is the petitioner, daughter of so-and-so, head of so-and-so, for securing her government job through fraudulent means by way of manipulation and cheating. Says Your Honor, I had secured my regularization of government by way of manipulation and cheating and drawing the dual salary from 2 establishment way of cheating and impersonation.
So we'll issue notice in this.
Yes, no.
Only notice.
Huh?
Only notice.
Oh, no, nothing is to be stated
Yes,
here.
Lordship, not.
We'll issue notice.
Yes.
Heard, Mr.
V. Jamo, Lordship. V. Jamo.
B. Jamu.
Yes, Lord.
B. Jamu, the learned counsel appearing for the petitioner. Also heard.
D. Loy.
D. Loy, the learned PP for the state. This is an application under section 528 of BNSS 2023 for passing of criminal proceeding arising out of FIR dated 14/7/2025.
Yes, Lord.
25, which was subsequently registered as ALO PS case number 42/2025, corresponding to GR case number 54/2025 under sections 318 in bracket 3, bracket 4/319 bracket 2/338 and 340 in bracket 2 of BNSS 2023. Issue notice on respondents.
Two.
It will issue notice on respondents by way of speed post. Notice to respondent number 1 is dispensed with since the learned PP has put in his appearance in the instant matter. The matter will be listed after 4 weeks.
Okay. Scan copy of TCR.
Scan copy of the TCR. TCR in connection with ALO PS case number 42/2025 to be called to be requisition from the court of.
So,
Where is this?
CGM Alo.
Huh?
CGM Alo, Chief Judicial.
From the Chief Judicial Magistrate, ALO. Is CGM ALO?
Yes. With that page number 11 of annexure 11 page 36 Lordship in the court of Chief Judicial Magistrate.
Page number
36 Lordship. Order sheet is there, Lordship.
Order is there. Correct. CGM ALO. ठीक.
Lordship, I have a small prayer in the next date, the interim may be considered if the investigation.
The interim order in the instant matter shall be considered in the next date of listing. Next date of listing. Let them appear. Let's see what
Yes,
is
sir.
there. I mean, there are some allegations against.
Deeply obliged.
Item number 10.
Yes.
Your Lordship.
Yes.
Lordship, this bail application has been pending since last month. Before,
Application has been pending from last month.
yes.
Yes. What is your case?
Your Lordship,
And what is the additional affidavit?
the additional affidavits, Your Lordship, I'm praying for parity, on parity ground.
Parity ground.
Parity ground.
What parity? Somebody has been given bail.
Yes,
Oh.
the prime accused has been granted bail.
Prime accused has been granted bail. What is the FIR?
Your Lordship, the fire is on page number 14. Annexure 2.
Charge sheet has been filed, not.
Yes, yes, yes.
Charge sheet has been filed.
Charge sheet has been filed.
You were inside the jail for how many days?
102 days
100?
till today. 102 days.
102 days.
Yes, yes.
Charge sheet has already been filed.
Yes, Your Lordship.
What is the stage in the trial now? Who is appearing for the state?
I'm appearing.
Any information regarding what is happening in the trial? Charges framed? No idea.
Not yet, Your Lordship. The
Not yet.
production has been done, yes.
Huh?
Production has been done.
You are on, I mean, who is on bail? The main accused, what's his name?
Uh,
Richie Anthony.
Richie Anthony, all the co-accused has also granted bail. And specifically, in this case, one Sri Pasang.
So how you are linked to this case?
Your Lordship, earlier I was arrested in the Itanagar PS case.
Hmm? But Rechi Thomas has been released.
Richie Thomas is also the accused in the Itanagar PS case.
So Itanagar police PS case, he has been released.
Yes, Your Worship.
And what about the other case?
Other case, in Dharmuk PS case, they have also released, but I could not procure the order, Your Worship.
You do not have.
I only procured the order of this Pasang Tamang. That's why I have filed one additional affidavit, and he is the prime accused.
Only cognizance taken. Not yet charge been framed.
Charge not framed.
Yes, sir.
Your Worship, though I have granted bail from the Itanagar PS case, but physically I am inside the bar since last 130 days.
Mr. APP, you are APP PP.
Additional PP.
Additional PP. I mean, he's already in jail and he main accused has been already released. Vehicles have been seized. What is the? I mean, I don't think there is more custodial detention is required. Charge sheet is filed. Everything is done. He'll face that trial, isn't it?
Yes.
Third, Mr.
J. Karbak.
Karbak, the learned counsel appearing for the accused applicant. কি question পূজানো হলো? Also heard Mr. G. Tado,
Yes.
the learned additional APP for the state. This is an application under section 483 of BNSS 2023 for release of praying for release of the accused applicant in connection with Doimuk PS case number 106/2025 under section 61/317(2)/3(5) of BNS full stop. The gist of the case, as has been narrated in the FIR dated 37 FIR dated 37/2025 is that the accused is that on receipt of certain information, the Doimuk police went to the place of occurrence on receipt of information about an accident. You write like that, okay? An accident. The police team reached the place of occurrence and found that a Fortuner car and a Bolero pickup car were involved in an accident, though there was no casualties as such. On verification and inquiry about the documents of the Fortuner, it was found that the owner of the Fortuner vehicle could not produce any valid document Therefore, there was a suspicion that the vehicle might have been a stolen one. It was also alleged that the owner of the vehicle, namely Locum Anthony, might have dishonestly purchased the vehicle from certain person involved in stealing of vehicles. So on receipt of the FIR, the police started investigation, and during investigation, it was revealed that the Fortuner car was given by Sri Taba Naku to Sri Jem Tado. Accordingly, the aforesaid Taba Naku was also arrested on 21/8/2025, and during his custodial interrogation, he alleged that the accused person, namely Sri Sagar Burman, is involved in the instant case of stealing and selling vehicles. Full stop. Next paragraph. Since the accused person was already in judicial custody in connection with another case, that is Itanagar PS case number 102/2025, he was shown arrest in the instant case, and since 27/8/2025, he is in judicial custody in connection with the instant case. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant was in fact granted a bail in connection with where was the order? That Itanagar, bail application.
Itanagar bail application.
You have been given bail in this Itanagar case, right?
Yes, you have.
Where is there? The order is not there.
No, Your Worship.
Why?
Your Worship, this Itanagar bail application was filed along with this
during the pendency of this.
during pendency of it.
But still, you should have had the bail order. So submits that during the pendency of the instant case, the bail application of the accused applicant in connection with Itanagar PS case number 102/2025 was allowed. However, since he has been shown arrested in the instant case, he is still behind the bars for last 102 days. The learned counsel appearing for the accused applicant submits that since the investigation is completed and charge sheet is filed in the instant matter, as well as the vehicles suspected to be involved in the instant case have already been seized and recovered by the police for the further custodial detention in the instant case may not be required. He further submits that a co-accused in the instant case, the main accused in the instant case, namely
Sri Pasang Tamang. Sri Pasang Tamang.
Namely Mr. mainly, no, his name is what is his name? His name is Ligam Sorawat.
No, Ligam Sora is the applicant. The main accused is Pasang Tamang.
Main accused. No, the name is also coming. Pasang Tamang, Pasang Tamang has already, who was also arrested in connection with the Doimuk PS case number 106 stroke 2025, was granted bail by the Court of Learned Judicial Magistrate First Class UPR by order dated 7/10/2025. 25. In view of the aforesaid, the Learned Counsel appearing for the accused applicant submits that since the main co-accused in the instant involved in the instant case, that is Doimuk PS case number 106/2025, has also been granted bail, and in this, and since charge has already been filed in the matter, this the accused applicant should be also granted bail at this stage. Full stop. Mr. G. Tado, the learned APP appearing for the state, submits that though investigation is completed and charge sheet has been filed, but charge is yet to be framed in the instant case, and the instant case full stop. He further submits that the accused applicant is involved in a racket which is involved with stealing and purchasing vehicles in this region. Therefore, he opposes the instant bail. This court has gone through the materials brought before this court, as well as the records pertaining to Doimuk PS case number 106 of 2025. 106 of 2025. Full stop. After considering the fact that the main co-accused in the instant case has already been granted bail, as well as the accused applicant is in judicial custody for last 102 days. This court is of the considered opinion that at this stage the accused applicant should be given the privilege of bail. Accordingly, it is directed that the accused applicant should be released forthwith on bail on furnishing of bail bond of rupees 50,000 with a security of like nature to the satisfaction of the which court? CJM.
Yes, CGM, Your Worship.
CJM UPR.
CGM UPR.
The satisfaction of the learned CJM UPR of Umpare district, subject to the following conditions. That the accused applicant, the conditions you can put it. No?
Your Worship, his father is a vegetable vendor. Yeah.
But he's involved in card lifting, so he must be having a lot of money, isn't it?
At least.
Okay, we'll make it 30,000. Okay, 30,000. 30,000. Fine.
If possible, 30,000. Your Worship.
That is not possible.
He is selling
His father is a vendor,
vegetables
but he's
in
a card
Gandhi
lifter.
market. Your Worship.
LA's card lifter. At least LA's card lifter, we can say.
That guy.
He's roaming around with bad company.
4 Fortuner, 1 Toyota were sold
Hmm?
by this accused.
4
Fortuner.
Okay, make it 15,000. 15,000 with surety of like nature, subject to the following conditions. First condition is that he will cooperate with the trial. Okay, as and when he's called for, he'll be there in the trial. He will not try to tamper or hamper with the investigation in any way whatsoever. Okay. And I'll put another condition. In view of the opposite direction, the instant bail application is disposed of as allowed.
Much obliged.
Item number 11.
Please, Your Worship. Worship, this bail application is filed under 483 of BNSS, praying for the release of alleged accused person.
He's inside behind the bars for how many days?
He is behind the bar for 145 days, Lordship.
What is his allegations?
Allegation is, Lordship, 103, murder.
Murder.
However, yes, Your Honor,
You have filed.
FIR is in page number 18 Page number 18 is FIR.
What is the
This is
state,
coming out of,
what is the stage of the trial?
CC has been done, Lordship.
Hmm?
CC has been done.
Charge sheet.
Yes, consideration of charge has been done. Charge sheet has been filed and consideration of charge has been done.
On what ground, this court should grant you bail? You have committed,
Yes, yes, Lordship.
committed a murder.
Yes, Lordship, I'll come to, I'll directly come to the findings of this, findings of the charge sheet. You want to
Findings of the charge sheet,
page number 27, Lordship.
page 27, yes?
Yes, Lordship. Findings.
Hmm.
The investigation revealed that on the intervening night of 16 July 2025, at about 2 a.m. at Konko village, Chimpu, the accused Tada Niting, aged so-and-so, son of late so-and-so, and the deceased late Tada Tagar, aged so-and-so, were both present at their family residence, along with their mother, Srimati Tada Yasi, and siblings Tada Tani, Tada Yaku, and Tada Anya. Lordship, here the accused is the youngest son, and the deceased is the eldest brother.
So like he came drunk and like there was a
Yes,
fight,
at
then he
2 a.m.
killed.
Yes, Lordship, I'll come to the Lordship.
I mean, elder brother came drunk. The
Yes,
younger
yes,
brother
that-
was studying for MA,
Yes,
and then he was having examination.
on next morning at
Next
10
morning,
a.m.
then he got some, he got irritated. Then they had a fight, then he killed him.
no,
And he
Lordship,
confessed that I killed him.
Lordship, here, the elder brother comes. as
No, I
well-
understand there was some,
Yes.
between the brothers, something happened because he was studying and the other one is drunk. The other
Yes,
one was drunk.
and not just drunk, he was assaulting the mother,
Hmm.
threatening to
The
bring
mother
down-
was not there.
The mother was there,
Mother
Lordship.
went off or something like that.
No,
is it?
later on, that was later on. Lordship may come to next para, Lordship. The deceased late Taratagar was married and lived separately with his wife at Papunala, but frequently visited his mother's house at odd hours in intoxicated condition. He had a history of creating disturbance, verbally abusing and physically assaulting.
Have you applied for bail in the trial
Yes,
court?
Lordship, yes. The only ground, principally, that is in page number 5354, Lordship.
50?
54, operational part.
54,
Yes.
yes.
Here, principally, it was rejected on the ground that all the witnesses are family members.
Hmm.
Therefore, there are high chances of tempering and hampering of the witnesses. Para 6, Lordship, page 54. After hearing learned counsel for both parties, I have carefully perused the case of the record and seen that the informant in the present case is the mother and 3 other witnesses are the sisters and brother of the accused person, and releasing of accused person before their examination at witnesses may hamper the trial of the case, as there is every possibility that in the event of release of the accused on bail, there may be hampered and temper of the witness who are relative of the accused person.
But
However-
this is a ground that has to be taken into consideration.
However, Lordship, here in this particular case,
No,
The-
see, you had a fight. There is no doubt. He may be a very good person, noble person, wise person. That is perfectly fine. But that doesn't give you right to kill someone. Correct?
yes, correct, Lordship,
So you have killed someone.
correct, Lordship,
So now there is, of course, the eyewitnesses are all family members.
correct,
And
Lordship.
this is one of the considerations why trial court has rejected the bail.
Correct, Lordship. However, Lordship, here in this particular case, even from the charge sheet itself, we can see that, we clearly see that. prima facie-
Sarsiris submitted, but these people were they have not been examined till now.
Yes, however, as per the charge, as per the investigation, findings of the investigation, your Lordship can clearly see that the deceased elder brother, he was the one who,
No, it
Hold
may
the
be,
doubt first.
it may be, somebody may give you a slap. That doesn't mean that you kill somebody, correct?
yes, correct, Lordship.
So in
Here,
this case, I don't think you'll get a bail at this stage. These people have to be examined.
Lordship, if in case, had it been like this, if the elder deceased brother had come with a lathi against his younger brother for talking against him or fighting in
But
self-defense,
whatever may be, Mr. Counsel, I understand your anxiety. I can understand that your client may be, in some sudden provocation, he has done it. But that doesn't mean that you'll get a bail, because thing is that nobody has been, till now, the deposition, the trial court hasn't taken a deposition of any of them.
Yeah.
And you have been accused of killing your brother.
yeah, Lordship.
It may be sudden provocation that will be decided by the trial court. But as this is, this court cannot decide about this, whether you were correct or you were not correct, whether there was sudden
Correct, Lordship.
provocation or not. I cannot decide on this.
Hmm.
So only thing this court has to take into consideration whether there will be some kind of, issues, because none of the witnesses have been examined as yet. Now, neither the accused person nor the informant, nobody. So at this stage, it will be difficult.
Lordship, here in this case, all the witnesses They are the first family members. And they
Correct,
all
that is,
agreed,
that is the reason more that, I
They-
mean,
Lordship,
I
they
mean,
have
they should be
already-
protected.
they have already stated before the IO under 180 BNSS, and they have agreed. They have all narrated the same story. There is no there is no denying in the fact that his brother is killed. However, the facts and circumstances of the case, we have to see that, Lordship. Here, the deceased brother was the aggressor, and the accused, there was no provocation from the accused side, Lordship. It was completely an act of self-defense or private defense, Lordship.
No, it was not only in self-defense.
Lordship, your elder brother came with the dao, and which probably is around 2 feet long dao, local dao. And their mother was present. The sisters were present, and sisters were also preparing for their examinations at that point of time. Her next sister had the prestigious Arunachal Engineering Service examination 10 days later. And that house where all this thing took place is a kacha house. Everybody could hear every other person. So, Honorable, kindly come to the findings. Lordship, from the findings of the charge sheet, we can clearly say that repeatedly he has been saying that he would kill the accused person, the accused person that very night. Again, he has also been shouting, either you or I will die tonight. These things are clearly mentioned in the findings of the charge sheet, Lordship.
Yes, Mr. Tado. What do you say?
Your Lordship has rightly observed that they are all family members. So at this point of time, when his released, then there's every chance of introducing the witnesses.
But it's an unfortunate incident, but I mean, you'll have to stay some more time.
Lordship, at this stage, he has already lost his,
How old is he?
he is 21 years old and he has lost his, he is MA first year student. He was ready giving for his final paper on very next day. So on
But looking into the entire things, I mean, it may be a little bit difficult at this stage.
Lordship may kindly come to page number 33.
No,
is the
that I have
statement of-
seen, that I want to.
Statement of one of his sisters.
I understand I mean, he was not an aggressor.
Yeah.
He was nothing, but looking into the stage, but thing is that it's not I mean, it's a kind of an injury kind of thing, or it's a killing of a person.
Yes,
The
yes.
killing of a person, the trial is going on, trial is going to be started. And at this stage, then there may be, I mean, a lot of issues.
Lordship, just one judgment, Lordship, maybe kindly allow me.
Yes.
Just one.
Yes, please. You give me a judgment wherein in similar circumstances, I mean,
Maybe Lordship. Here also, the accused had killed his father,
Hmm.
who was bedridden,
Hmm.
who was in a vegetative state. Because of the repeated abuse against the accused as well as his mother,
Hmm.
even while being in medication, here the apex court has granted bail, seeing
okay, well, but let me,
Yes.
I mean, take me to the relevant paragraph.
paragraph 23, 24, Lordship. Lordship, before that, Lordship may kindly come to
That factual part.
yes. Paragraph 4, Lordship.
Paragraph.
4, Lordship.
This is Mumbai High Court.
Yes, Lordship.
This is not Supreme Court.
Oh, yes. This is Mumbai High Court, Lordship. The
Hmm.
other one was Supreme Court, Lordship. My apologies. In the above backdrop, paragraph 4, Lordship. In the above backdrop, on the date of incident, it is seen that around 1:30 hours, applicant returned from home from his college. He completed his higher secondary certificate school examination, having secured 78% marks, and was further pursuing further education as second year student of Bachelor of Management Studies in KV so-and-so college. The record also shows that the victim was a chronic alcoholic suffering from kidney ailment and used to consume tobacco, leading to his medical conditions. Para 5. The mother of the applicant and wife of the victim was not present in the house on the date of the incident, as she used to work as housemaid. Records show that on the date of the incident, prior to the incident, between 1:30 p.m. to 5 p.m., the applicant had his lunch after returning to college and was present in the house, and on the couple of occasions, the victim, that is the father, passed urine and applicant aided him to pass urine in the urine pot and also washed the urine pot and kept back in the same condition. Para 6. However, at about 5 p.m., the victim was taking certain medication tablets which were opposed by the applicant on the ground that the said tablets were not prescribed by any physicians and that they would ultimately harm if they were taken without prescription. This intervention of the applicant was not taken kindly by his father. The victim, who was visibly suffering, and there was a verbal altercation between the father and the son, which escalated further. For a long time, even prior to the incident having happened, the so-called verbal altercation between the father and the son persisted, and it is seen from the record that the father victim, in view of the ignominy suffered by him, was constantly hurling abuses on the applicant and also his mother. This repeated barrage of abuses had deleteriously affect the young mind of the applicant, and like any other young son, he retaliated by asking his father to shut up and mind his own business, and while doing so in return, ended up abusing him. All this is confessed by the applicant in his statement, which is according so and so. Lordship may directly come to paragraph 8, Lordship. What transpired thereafter is that applicant came out of his house and bolted the house from inside, went to his immediate neighbor, borrowed ₹100 from the neighbor, and thereafter took a rickshaw and approached the nearest police station, where he went and confessed have killing his father and narrated the incident which had occurred. Here also, Lordship, this accused had himself.
Okay, now
surrendered
come
the
to
police.
paragraph 23.
Yes, Lordship. Paragraph 23, Lordship. Before me is a case of young offender, and as held above, his exclusion from the normal education stream for a period of time brings about unpleasant consequences and harm, which in any case, amongst other, is the purpose of any punishment. The applicant before me has admitted the act by himself walking to the police station, giving information to the police. He could have run away had he been a different criminal tendency. At this stage, I'm not considering its evidentiary value. The confessional statement, when read, would show that the petitioner is contrite. He is young adult offender. He clearly falls under the category of young adult who has crossed his age of juvenility but is less than 21 years of age at the time when the offense is committed. It is widely recognized that the younger age of the offender, the lesser is its culpability. Therefore, having regard to the totality of the circumstances before me at this stage on the prima facie consideration, I'm inclined to consider the applicant's case. It should also be noted that in case where young offender is undergoing studies, his exclusion from education for a period of time is an added layer of punishment over and above what a non-student accused may have subjected to. This is because a student undergoing incarceration suffers loss of precious academic time, which cannot be bartered for any wealth in the world. He also constantly witnesses his peers moving ahead in the life then compared to him. And when the frustration becomes insurmountable, such frustration can create an emotions of rebellion, which coupled with the exposure to criminality in prison can easily gain traction and push him to become a hardened criminal. This court can only make an attempt and should make an attempt to positively impact the life of the applicant before it. It is on the belief that the applicant, having once gained the confidence of court, would make a sincere attempt to reform and rehabilitate himself due to his academic credentials achieved in SSC and HSC exams, and he is studying the management degree course despite heavily odds stacked against him. Considering the foregoing, I'm of the opinion the applicant should be given chance to make an attempt to demonstrate that he has reformed his conduct in leading a law-abiding life with prospect of suspension. Lordship, in our case also, even this I annexed that also. In our case also, the accused, he is a very bright student, brilliant student. He is passed higher secondary from a government college, a government school. Yet again, he has secured 76% in from Polo Colony High Secondary School. Thereafter, again in his graduation also, Lordship, he is passed in first division, even after passing out from a government college, from Deranatun Government College. Thereafter, he was preparing for, he joined MA and he was preparing for his second semester last paper examination on that very day, Lordship. And in the very next room, his sister was preparing for the prestigious Arunachal Engineering Service examination, which was to be held on 27 July 2025. That is 10 days later of the incident. So entire situation was very peaceful and academically they were focused. However, because of the irresponsible deceased brother, who is the eldest son and supposed to be taking care of their younger ones, who is supposed to encourage their younger ones to study well, he came late at night and he started abusing the mother and other family members, disturbing the other family members, and stating that either I will kill you or I will kill you tonight or I will die tonight. Making such statements, Lordship.
See, I'll consider this. I mean, I'll consider this. I'll consider your submissions, and I'll see like what can be done. I'm not. I'm not saying that like I'll be granting you the bail. Neither I'm saying that I will not be granting you the bail. But I'll pass an order. I'll pass a reasoned order. I'm looking into the entire facts of the case and taking into account. I mean the situation, the fact situation in the instance was. So I'm not passing the order as of now because I would like to write something on this.
Lordship, I have enclosed all the statements of the witnesses, and all of them have agreed.
Because this is a very delicate case, and wherein you have been accused for for murder, and all the family members are witnesses. The only thing which needs to be considered is about your age, about your education, and about your character as a person.
Lordship.
It seems to be good. It seems to be a decent person who was studying and all, and in a peculiar facts and facing with certain situation, you have killed him. So those things we will consider, and we'll consider this will pass him.
Before concluding,
please take his name and APP's name.
Lordship, before concluding, I also would like to mention that this boy has been preparing for CHSL exam, CGL exam.
That is not an excuse. I mean, you prepare for IAS, you prepare for CLAT, you prepare for MBBS. That doesn't give you a reason to kill anyone, correct?
Lordship.
You cannot kill anyone. But only thing, certain things needs to be considered. I mean, since he's a young boy, I mean, whether putting behind him will be fruitful or like it will go against his, certain things has to be considered. So we will consider those things.
At next,
And
Lordship.
and we'll see what order can be passed. And there is no nothing has been commented by this court on merit. We will decide it and we'll pass the reasoned order.
Lordship.
Correct.
Oh, that was.
Item number 12.
Lords, in view of the order passed by this honorable court on the last occasion, there was a direction to the prosecution not to take any course of action against the petition. Accordingly, I have appeared before the IA, recorded my statement.
This is AV.
Lordship, we received the status reports, Lordship,
Hmm.
wherein the IO fairly stated that their statement was recorded and their custodial inquiry.
So let this be, let him be made absolute.
Yes, Lordship. Yes. Right, there is.
By the time we have moved this application, there was an FIR, but the FIR was not registered. But later on, I have learned that the FIR has been registered. So that's the reason we have not specifically mentioned the FIR number. So it may be with the prosecution.
No, that is the status report, Lordship. Down below, Lordship, the bail comment, Lordship.
Heard Mr. Zering, huh?
Yes.
Mr. J. Zering. How do you pronounce this?
Jambed Sering.
Jambe Sering. Jambe Sering Ki.
Kim. He is the title which I have used.
KW.
KW.
And Sering is the middle name.
Jambed Sering. Sering is the middle name.
Okay. Heard Mr. J. Sering Ki, the learned counsel appearing for the accused applicant. Also heard Mr. D. Loy, the learned public prosecutor for the state. This is an application under section 482 of BNSS. BNSS paying for grant of pre-arrest bail to the accused applicant in connection with you haven't given any case number also?
Yes, my lord. Initially, there was an FIR, but the FIR was not registered. So on genuine apprehension, we have moved this application. Now, my lord, the prosecution has produced some documents, my lord, which may contain the FIR number.
In connection with Itanagar WPS case number 75/25 under section 69 of BNS. The gist of the case as has been alleged in the FIR dated 5/11/2025 is that a retained complaint was received from one MSX, name not mentioned, being a lady in bracket, X, alleging that the accused applicant had induced her into a sexual relationship on the false promise of marrying her since the year 2018. Full stop. It was also alleged that the informant came to know about the marital status of the accused applicant and found that the accused applicant is a married man. Full stop. In view of the filing of the aforesaid FIR, the instant case, that is WPS case, don't write instant. On receipt of the FIR, WPS case number 75/2025 under section 69 BNS was registered against the accused applicant. This code, the coordinate bands of this code wide order dated 11/11/2025 was pleased to grant interim pre-arrest bail to the accused applicant to the effect that no coercive measures would be taken against the accused applicant. Full stop. Mr. D. Loy, the learned, first right, Mr. Chairing, the learned counsel appearing for the accused applicant submits that the accused applicant, in terms of the order dated 11/11/2025, has already appeared before the concerned IO and got his statements recorded. He further submits that the accused applicant is a responsible citizen who is very much willing to cooperate with the investigation in the event that this court grants him the privilege of pre-arrest bail. Full stop. Mr. D. Loy, the learned public prosecutor, has submitted a status report dated 5/12/2025 before this court, which has been kept on record by marking it X, which reveals that the accused applicant has in fact appeared before the investigating officer, and his statement has already been recorded by the IO. It is also seen from the progress of investigation mentioned in the status report that victim complainant has complainant has also been examined, and her statements have been recorded under section 180 BNSS. Full stop. Looking into the status report as well as the fact that the statement of the victim complainant has already been recorded by the police, already been recorded under section 180 BNSS. This court is of the considered opinion that the interim order so passed 11/11/2025 should be converted to an absolute pre-arrest to an absolute relief under pre-arrest bail. Accordingly, it is directed that the accused applicant, he have been allowed to go on bail or what? Not bail.
Not bail.
Only
records it.
recorded.
And there was no terms and conditions.
Correct. So it is directed that the accused, in the event of the accused applicant is arrested by the investigating officer in connection with WPS case number 75/2025 under section 69 of BNS, the accused applicant shall be released on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with a bail bond of 20,000 with a security of like nature to the satisfaction of
Arresting authority.
to the satisfaction of the arresting authority in connection with the aforementioned case, subject to the following terms and conditions. Number one, he'll appear, you again appear before the thing, for
Well-
furnishing, you furnish your bill one, within 10 days we appear,
10.
furnish your bill one, and cooperate with the investigation, those conditions will be mentioned there.
Well-
In view of the aforesaid directions, the instant bail application is disposed of as allowed.
Grateful.
Item number 14,
Some. Unlisted queues. Anybody around it, but notice I'm not very good.
Ma'am. Lordship, in this matter, I have taken steps against the sole respondent, Lordship.
Sole respondent, I mean, this is POXO matter. Or what?
Lordship, no, Lordship, this is,
So we'll wait for this. Service report in respect of sole respondent is not yet received. So we'll have to wait. There is no other way.
Lordship, otherwise also I.
When it was taken,
Lordship, 9. In the month of October, I think.
I mean, who is the PP? In this case, who is appearing?
So Lordship, our name was not, our state was not reflected, Lordship. So state
Item number.
item number 14.
14 Lordship.
14.
Yes, Lordship. State was not reflected, so we are not aware of this, Lordship. Extremely sorry, Lordship, but
But Genie was, no. Genie is not there.
Lordship, state was not made as a party, Lordship.
State is not a party.
Lordship.
Why?
It's arising out of a complaint.
What, I mean,
Complaint
still, I mean, this is a POXO matter.
No.
What matter? It is not a POXO matter. I have been asking you, what matter is this?
This is not a POXO matter, Lordship.
Oh, this is not a POXO matter.
Lordship, this is, it's
Mhm.
this
Then
case
you-
is arising out of a complaint case.
Then you'll have to wait, So, I mean, heard Mr.
JG, Lordship.
J. Gini.
JG.
J. Gini, the learned counsel appearing for the petitioner, appearing for the appellant. Appearing for the appellant, full stop. Office note dated 4/12/2025 reveals that service report in respect of the sole respondent is yet to be received. Let the matter be fixed in the next week. Next week or after the vacation?
Lordship, after 2 weeks, can it be?
Then it will go to vacation. Let the matter fix after the ensuing vacation.
That's it.
Item number 15,
This is POXO matter. Appeal against acquittal.
Lordship, I'm agreed by the acquittal, Lordship.
Yeah, why it is common orders? Okay.
For the first time.
This come for the first time, we'll admit it and like we'll issue notice on.
All right.
Heard Mr. J. Gini, the learned counsel appearing for the accused, appearing for the appellant. Also heard Mr. T. The learned APP for the state. This is an application, this is an appeal under section 413, read with section 423 of BNSS 2023 against the judgment and order of acquittal dated 4/8/2025 passed by the learned special judge POXO, Pasighat, East Siang district in PSG SC in bracket POXO number 10/2025 in corresponding to Gen-C PS case number 02/2024. So you have come against the acquittal.
Lordship. Lordship, I'll be taking steps respect of respondent number 2.
We'll
One-
admit this, right?
One already,
Or only notice. I mean, this is statutory appeal probably.
This matter, it's
there is
It's appeal against the acquittal.
yes, my lord, leave is not required. My lord, it can be admitted and the notice may be issued
So
to the
leave is
acquitted
not
person.
required. This is a statutory one.
Yes, my lord. Earlier, your lordship, the leave was required, but when it's preferred by the victim itself or the family member, then leave is not required.
Leave is not
Only when state prefer, then only leave is required. So the appeal is
So we can
preferred. by-
admit the appeal.
Yes, my lord.
We can admit the appeal.
Yes.
Admit the instant, admit the criminal appeal. Full stop. Issue notice on respondents by way of speed post. Full stop. Steps to be taken within 3 days within 3 days of passing of this order. Notice to respondent number 1 is dispensed with since the learned APP has put in his appearance in the instant case for respondent number 1. Full stop. However, extra copies shall be requisite number of extra copies to be served on. We already received problem,
Yes, my lord. I have received the copy.
but you don't need any more.
Extra copy is not required.
Not required. Extra copies don't write. Extra copies don't write. Let the matter be listed after 4 weeks.
TCR.
And TCR in the instant case, TCR in the instant case, the registry to requisition, the TCR in the instant case from the court of the learned special judge, POXO, Pasighat, Arunachal Pradesh. Correct?
After 4 weeks.
After 4 weeks.
Obliged.
Item number 16.
None appears when the matter is called for. Let the matter be listed after the ensuing vacation.
Item number 17.
May I please, my lord?
Hmm.
My lord, I was supposed to take fresh steps upon respondent number 2.
You haven't taken
Not taken, my lord.
hard, Mr.
M. Dojima.
and Doji, the learned counsel appearing for the
Petitioner.
appearing for the petitioner. Also heard Mr. D. Loy, learned PP for the state. Office note dated 4/12/2025 reveals that fresh steps in the instant case is yet to be taken by the petitioner. It is directed that it is directed that the fresh steps to be taken within a period of 3 days from today by the learned counsel appearing for the petitioner.
Obliged.
Item number 4 and 5.
Yes.
Lordship, they are not filing this objection and affidavit. The opposite party, that they are not filing the objection that I have discussed with the senior counsel, Deep Angin, that matter may be fixed for this lordship hearing.
Where is he? Where is he?
His legs in court too, man.
You are not filing an objection. 4,282 days.
My lord, we are appearing in item number 5 only, man.
Huh? You are appearing for whom?
Respondent, my lord, in item number 5 only, man.
Item number 5.
Yes.
This is item number 4 over.
We are not concerning about item number 4.
So why both the matters are together?
Lordship, this connected matter, Lordship. Then this pleading has been completed, and this item number 4, Lordship, service has already been received. They are not contesting it.
It was improved. A2. Addition. So you are appearing in item number 5.
Yes, ma'am.
Item number 5 for respondents, right?
Yes, ma'am.
They connected by the same matter only.
Lordship.
Maybe, my lord, but
We have not instructed to appear in item number 4. ma'am.
Item number 5, you are not filing this thing.
No, ma'am.
Item number 5 is in time over.
Lordship, even item number 5, there is no any affidavit of reply, Lordship.
No.
And
Item
this is
number
just subsequent, Lordship.
development.
Yes.
But why you have filed a separate CRB for this?
Lordship, in fact, item number 4 was filed for the one cover decision in 2000.
Correct.
And
And there there are 4,000 some delays there.
Yeah, Lordship.
And the delay has not been condoned as yet.
Lordship,
And they have not filed objection.
exactly, Lordship. They have not filed objection.
So let, let the council be there. Let it be fixed. On the joint prayer of the council appearing for the parties, let the matter be listed after the vacation. After the vacation, you decide whether you need to file or not.
Yes.
After the ensuing vacation. Mention their names. Okay, these two matters after the vacation. Because let them, if they, there are 4,000 some days are that delay. So let him consult, whether they want to file affidavit, objection or not.
But the same discussion was taken place, this because of this.
But nobody has come and stated before this court. That's why. Okay. Let it come after the vacation.
Lordship, in item number 5, there is an interim, Lordship. This may be continued. Item number
Item number 5, there's an interim.
Yes, Lordship.
In item number 5, you write
Revision point 31, 2022, Lordship.
Dated, where is the interim? See, you have already taken time to file objection in this matter also. There is no interim, or interim is there.
Yes, Lordship.
But interim order, where is the interim order? There is that I could not find.
Lordship, 7/6/2022 order.
7/6?
7/6/2022, Lordship.
7/6/2022.
Yes.
7/6/2020 order is not here on the record. Why?
Lordship, till reasonable.
7/6.
Yes, Lordship. 7/6/2022 dated, Lordship. Order passed on 7/6/2022. In year 2022, Lordship was.
No, I'm not finding in the record. That's what I'm looking for. 7/6.
2022, Lordship.
Okay, this is, this was passed in item number 31.
31.
31 is item number what? 4.
Lordship, this is also for the causing of the one Lordship decision.
5, no? Item number 5 you write. Interim order passed earlier shall continue till the next date of listing.
All right.
Item number 6.
May I please, Your Lordship? My lord, we are praying for disposal of this matter.
Disposal will be difficult today, some other time.
Not sure.
Hello, this is the second day. We have fixed for disposal of the matter.
No, I
Actually,
don't know
due
about
to
other thing,
paucity of time last week, it could not be taken up.
Some other time. Today it will be difficult.
After vacation.
Not much.
After vacation, then, my lord.
After vacation.
Let the matter be listed after the ensuing vacation. Record their names, sir.
Lordship, there's an interim order.
Interim order so passed earlier shall continue till the next date.
Obliged.
Today it will be difficult. Some other day.
Item number 7.
The lawsuit for criminal petition filed by the petitioner for setting aside and crossing of the criminal proceeding against the petitioner in connection with Nalagan PS case number 05 of 2000.
Hmm. So you want to argue this matter today?
Yeah, Your Lordship, I find the additional affidavit.
Hmm.
In the departmental inquiry also, it's already clearly and
So today it won't be possible, but
Yes.
she was exonerated from.
when do you want?
Next week, Lordship.
On the prayer of Mr. Huh?
10th.
10th.
December.
10 December is day after tomorrow only.
There.
Next week something. On the prayer of the learned PP. Let the matter be listed up in the next week.
Item number 8.
Your Honor, here the respondent, they have find the,
Hmm?
here the respondent, they have find the affidavit in opposition, Your Honor.
You will file reply.
This matter may be listed for hearing, Your Honor. I've received the copy of the affidavit in opposition, Your Honor.
You will not file reply.
I'm for the petitioner,
You are Mr.
H. Tai,
Mr. Learned Counsel appearing for the
petitioner.
petitioner submits that pleadings in the instant case is already been completed. He prays for listing of the matter for hearing. Let the matter be fixed for hearing after the ensuing.
Your Honor, the respondent has informed me to list the matter on 19th of January, Your Honor.
Okay, let the matter be fixed on 19th of January.
Declare.
Item number 9.
This is a joint petition for causing of an FIR on settlement.
Yes, Lordship, but
It is come for what?
come for Lordship admission hearing, Lordship.
Hmm.
But here the Alice accused are the juvenile, Lordship. Juvenile, and they have settled their differences, and the stolen article was recovered and nicely compensated, Lordship. I have no objection with Lordship. The accused, Alice accused, they are the student of Lordship, class 7, Lordship.
Class 7?
Yes, Lordship. That's why, Lordship, considering their Lordship future.
It's a joint application.
Yes.
Kept a mobile phone.
Yes.
And some eatables, Lordship.
Biscuits and some Maggies.
Laptop, mobile phone, and some eatables from his shop.
Yes.
Okay, we'll pass an order. We'll allow this.
Yes, sir.
We'll allow this. Only thing is that, I mean, certain things has to be, I mean, mentioned here. So we'll pass this order, but write the names.
They are also restricted from the school also, Lordship. Restricted from the school also.
They're from the school. Both are, I mean, class 7 student.
Class 7.
In a hurry, FIR was filed. Same locality, in the same school.
Same locality.
Same school or what?
Yes.
Both study in the same school.
Yes.
Unnecessary. Anyways, we'll allow this. Yes.
All right.
It is order possible.
Item number 21.
Lordship, I am for the petitioner in this case. This petition is under section 528 of BNS for quashing FIR. Under section 318 of BNS registered at PS Naharlagun.
Today it will be difficult to take up this matter.
Lordship, my submission is very short because
there is some difficulties today. We have some other things.
Actually, Lordship, I had appeared physically on the last date of hearing, but due to DB, my case was postponed. So my submission is very short, only 1 minute,
No,
Lordship.
I understand, but like this court has some things lined up today, so that is the problem. I mean, it will take some time. I know this. What is your
Lordship,
case?
Actually, Lordship, this is the case of 318. And Lordship, the present FIR arises out of commercial transaction between two businessmen. Actually, there was a business transaction of 9 lakh rupees between petitioner and respondent. Respondent number 2 has paid 9 lakh rupees for kitchen steel equipment, purchasing the. Unfortunately, after goods were prepared, a dispute was aroused due to some misunderstanding. However,
Okay,
mutual,
when can you do it?
yes,
When can
Lordship,
you do it?
a mutual compromise has been reached between
No,
the
no,
two.
when can you do it? When can you do it? I mean,
Yes,
today
Lordship,
it won't be
mutual
possible.
mutual compromise has been settled, and 9 lakh rupees, that is questionable amount, has been returned. FIR has
So
been
day
lodged.
after tomorrow, day after tomorrow you can appear?
Please, Lordship, please fix it for day after tomorrow or tomorrow,
Day after
Lordship.
tomorrow will, day
Tomorrow,
after tomorrow will take up. Day
Right,
after
yeah.
tomorrow, you're stationed where?
I am from Delhi.
Station.
I am from
Okay.
Delhi.
The day, by VC you appear on day after tomorrow?
Yes.
Mr. Dubey, you are appearing or what?
Lordship,
Dubey is appearing? Mr. Dubey, are you appearing?
no, Lordship, he's not in my case.
I'm not
He's not
in this case, Lord. I have
Lordship,
to
my
make a
submission is,
mention. I'm not
Mr.
in
Dubey,
this. I
please
will have
wait.
to.
Please. Lordship, my submission
So
is
we'll
only
fix
this.
it up on day. We'll fix it up on day after tomorrow. Okay.
Please fix it on the top of the list, Lordship, kindly.
The top of the list not possible. Let the matter be fixed on day after tomorrow. That is on 10th of December. Lord.
Right,
10th
Lordship.
of December.
Right. Please, oblige, Lordship.
Item number 22, unlisted motion matter.
If your Lordship permit, Lord.
Lordship, the accused has already undergone 110 days behind the bar, Lordship.
Yes.
Already charges has been framed against me, Lordship. The witnesses are to be examined, Lordship. The witnesses, the victim and 2 more other witnesses, they have been called for examination on 2nd March of 2026, Lordship. This is a subsequent bail application, Lordship. Previously, the bail, which was filed before the special court, was rejected, Lordship.
So we'll have to issue notice on this.
Lordship, notice may be issued. The informant, victim, as well as the victim has to be
Yes,
served copy through PPI.
correct. Heard Mr. R. Dubey, the learned counsel, appearing for the accused applicant. Also heard Mr. D. Lowy, the learned PP for the state. Respondent state, that is respondent number 1, full stop. This is an application under section 483 of BNSS 2023, paying for granting bail to the accused applicant in connection with Itanagar Omen Police Station case number 7/2025 under section 75 in bracket 2 of BNSS read with section 10 of POCSO Act, full stop. Issue notice to respondent numbers 2 and 3 to the registry as per the prevailing notification of the Honorable Guwahati High Court. Full stop. Let the matter be listed on when?
Lordship, can it be on Friday, Lordship? Friday, coming Friday.
Coming Friday, how notice will be served and who will be appearing? Is
Lordship,
it possible?
if it is taken through,
Lordship, with regard to the notice, that we can do, but with TCR is TCR is
TCR will not
called
be
by the
coming.
registry.
Registry to call for TCR in the instant case in connection with Itanagar WPS case number 7/2025 from the court of which court?
special court UPI, Lordship, it's nearby only.
Special court UPI.
Just nearby only, Lordship.
If TCR arrived, then
But notice can be served
notice, Lordship, we will try, Lordship.
from your office to
Yes,
from your office to the
OCPS, Lordship.
I mean,
PS, Lordship.
okay, if notice can be served, then it's well and good. Let the matter be fixed on. You fix it on Monday, Mr. Dubey.
Milord,
Let the matter be fixed
Milord.
on Monday. I don't think it really possible because my experience says
Milord.
that I mean it will not be possible.
Sorry to intervene, Milord. In fact, I am not appearing in this case. Probably my lord has wrongly recorded
he's
that.
not appearing.
Milord, I was appearing for a mention, Milord.
I've been told that like, you are appearing in the matter. Anyways,
Milord, I was appearing in item number 2, Milord. Milord, actually I missed because of the miscommunications, Milord.
Write his name. Write his name. Let the matter fix on Friday then. Friday is, I mean, Friday is 12. Yes.
Lordship, it's 12, Lordship.
This is item number 22.
Lordship, item number.
Yes.
Milord, can I make mention, Milord, if your lordship permit, Milord?
Yes. Which matter? I mean, you have
Item
your.
number
I
2.
can see your. I can see your face from the very beginning.
Yes,
So I
Milord,
was
in fact,
thinking
I was
which-
there the whole first half, Milord, because your lordship was sitting in division bench.
So I
And
mean,
while-
this. I mean, the order has been passed in this matter. What has happened?
Item number 2, Milord.
Huh? Item number 2.
My lord.
Yes.
Milord, this is basically
number
for
2.
quashing of the Milord impugned complaint proceeding, Milord. Milord, it arises out of a civil dispute, Milord. Milord, if your
Yes,
lordship would kindly say,
yes. Now I have seen that. We will issue a notice on this.
Milord, I am praying for a stay, Milord, because your lordship sees under 223 there is
We'll
a
stay.
mandatory.
My lord. We'll stay.
My lord.
I've seen this. We'll stay.
My
Heard
lord.
Mr. R. Dubey, a learned counsel appearing for the petitioner. Also heard Mr.
Lordship,
D.
this
D.
matter was
Loy.
earlier appeared by one of my colleagues, Lordship, T. Jenny, Lordship.
No, there is no order passed here.
Oh, yes.
It was passed over.
Lordship. After 1 week, Lordship.
It was because nobody was there, so we passed it over. And Mr.
I will go through the brief also, Lordship. It's
Milord, it is a
typical-
private complaint. The state has nothing to do with that, Milord. It's only a formal party.
You are only a formal party.
Let me see.
Mr. D. Loy, the learned PP for the respondent number 2. Respondent number 2, state. Okay, comma state. This is an application under section 528 of BNSS. BNSS assailing the order dated assailing the order dated 17/7/2025-24 passed in CR case number 5 of 2024. Whereby process was issued, right?
Yes, cognizance was taken, Milord, without being any
Whereby-
reasons and without giving
Which was
pre-cognizance.
the order? Order dated 4/4.
17/7. Page 30,
Order
Milord. Last
77. Whereby cognizance was taken by the court of Chief Judicial Magistrate 0 district district Lower Subansiri, Arunachal Pradesh. Full stop.
Milord, we are also challenging the complaint petition itself, Milord, initiation of the proceedings, as well as the
That we'll
order
see
review.
later on.
Milord.
That will be seen. The case of the petitioner in the instant case is that the complainant that is respondent number 1 has filed a complaint petition. A complaint before the learned Chief Judicial Magistrate 0 Arunachal Pradesh, alleging that the petitioner had borrowed its sum of rupees, sum of rupees, sum of rupees 15 lakhs on 27/12/2021, as well as another sum of rupees 7 lakhs on 28/3/2023 by executing two separate undertakings whereby he promised to return the money back within a period of 2 months. Full stop. Since the money was not returned to the complainant, that is respondent number 1, the complainant has filed a complaint before the Learned Chief Judicial Magistrate 0. Full stop. Full stop. The Learned Chief Judicial Magistrate subsequently on 17/7/2024 has taken cognizance in the matter and issued process under section 204 CRPC. Full stop. The petitioner being aggrieved by such orders of issuance of office has challenged the same before this, challenged the same amongst other before this court. Full stop. Mr. R. Dubey, the Learned Counsel, preparing for the petitioner, submits that the issue involved in the instant case is totally of civil nature, wherein some monetary transactions occurred between the complainant and the petitioner. Therefore, the complaint petition that has been filed before the Chief Judicial Magistrate, or the Learned Court of Chief Judicial Magistrate, is not on basis of any settled law, not on the basis of any settled law, and the Learned Trial and the Learned Court of Session has wrongly issued process in the instant case. Full stop. Issue notice to the respondents by way of speed post. Full stop. Notice to respondent number 2 is dispensed with since Mr. D. Loy, the Learned PP, has put in appearance on behalf of respondent number 2. Full stop. The trial court registry to call for the PCR in the instant case from the court of Learned Chief Judicial Magistrate 0. Full stop. It is, till the disposal of this case, in interim, till the disposal of the case, the proceedings before the Learned Chief Judicial Magistrate 0 in the instant 0 in connection with CR case number 5 of 2024 is hereby stayed. List the matter after the ensuing vacation.
Deeply obliged, notes.
Item number 23.
My Lordship. Lordship, this is the connection with the Dumprijo Police Station case number 16/2025. For under section 21B of NDPS, I did with 3/5 BNS.
What was the quantity?
Yes, quantity was is about 7.8 gram.
7.8 gram of heroin.
Yes, it is intermediate. Yes, so, and your Lordship, the accused person is
You are inside the jail for how many days?
almost 82 days, sir.
82 days.
Yes, sir. Lordship, the circumstances that now my father is a ailing patient, and he has been in the
Mr. Loy,
Yes, Lordship.
and now my mother has been
82 days already.
yes.
82 days. No charge sheet filed. No charge sheet filed.
Lordship, I don't.
Lordship,
No.
without going through the Lordship, okay, case dated Lordship.
Now, 82 days has already been passed.
Yes.
Yes.
Already there is no record of interpretation. Already my statement has given to the.
Maybe file lordship, since he is not annexing any document with.
But, Lordship, this is, I have.
City maybe call for lordship.
So we'll call for the CD. We'll put it in the, I mean, on Thursday.
On
Yes.
remand.
Thursday or
Yes,
Friday.
yes, in this, if not file lordship.
Oh, no, already 82 days passed. No?
Yes,
Yes,
lordship. I understand lordship.
So you take instruction, we'll put it up on Wednesday.
Wednesday.
Huh? Wednesday?
Lordship.
Yes. Yes, Lordship. Wednesday, it urgent because my father is a ailing patient and I have no
Lordship
mother.
next week or
No.
it's
No, this week only.
This week only.
This week sometime in
then be it on lordship 11 lordship.
Huh?
Be it on 11 lordship.
11th.
Yes, lordship.
Okay, 11th.
Lordship,
Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. D. Loy, the learned PP for the state. Is an application under section 483 of BNSS 2023 for releasing the accused applicant on bail in connection with Doom Porizo Pool PS case number 16/2025 under section 21 in bracket small b of NDPS Act 1985, read with section 3 in bracket 5 of BNS 2023. Call for the CD. Let the matter.
Scan copy lordship.
Scan copy. Yeah, call for the scan copies of the CD. Let the matter be fixed on 11th December.
Yes.
Definitely.
Item number 24.
Yes, Lordship, this is same case. Here the.
Raising of the same.
Same affair, same case.
Same affair.
Yes. Yeah, this is the, my sibling, same sibling, my brother.
Your brother.
Yes. The both son are in the custody and my father is alone in the.
Okay, same order in this also.
Yes. Deeply obliged.